We now come to the next section. We're still in Part 3, Chapter 3, Insolvency Resolution Process. We've now seen how the application is preferred under the Insolvency Resolution Process, appointment of the RP review of the application, acceptance, rejection by the RP, it goes to the adjudicating authority, and adjudicating authority has passed an order admitting the application. And then there was a moratorium, there was a public notice, there was a collection of claims, and there was a preparation of the list of creditors. Now we come to the next, which is on resolution plan. Now all this was a certain linear process. Now suddenly there's a new concept, which is actually the core of this whole process. The core of the insolvency resolution process is to prepare a repayment plan. It's, by the way, called a repayment plan, whereas in corporate insolvency process it's called as a resolution plan. The section says 105, the debtor shall prepare. There it was resolution applicant shall prepare in the corporate process. So the debtor in consultation, the RP in consultation, the debtor in consultation with the RP shall prepare a resolution plan containing a proposal to the creditors for restructuring of his debts or his affairs. The repayment plan may also authorize or require the resolution professional. Sometimes in the resolution plan, repayment plan, the RP himself may be authorized to manage the affairs, to realize the assets, to dispose the funds. And incrementally, what are the contents of the repayment plan? First, there are only 3 contents here. First, always remember the process cost should be provided. So fee here payable to the RP should be provided. Next, all repayment plans have to conform with laws and regulations prevalent at that time. So it shall comply with other matters. And here that's of course a given. Justification for preparation of such repayment plan and the reasons on which the creditors may agree upon the plan. That is, where a repayment plan is given by a debtor, he has to give the repayment plan, and he also has to say why the creditors will agree to that plan and the justification for that plan. It has to provide for the payment of fees and such other matters as may be prescribed. So you will notice when the prescription comes, all this compliance with laws, regulations, etc. may come. But please remember, for the purpose of this section, repayment plan does only 2 things. It has only 3 conditions and 3 actions it may permit the RP to do. If you contrast it with the resolution plan, there are quite a few conditions. It says it has to provide for the insolvency process cost. It has to provide for liquidation value to operational creditors. It has to comply with the laws for the time being which are in force. It shall provide for implementation. It shall provide for supervision. It shall provide for such other matters as may be prescribed. Whereas here it is only a 3 plus 3. Please remember. And 106 is the report on the repayment plan. See, if you just submit a repayment plan, it's not that the process adjudicating authority will take it and go through it and say, okay, it's good, it's not good. So they said no. There we had a committee of creditors that was approving. Here, before that committee of creditors approving, there is a formal structure for a report on the resolution plan, repayment plan. Now this report on the repayment plan shall be done within 30 days from the last date of receipt of claims under the public notice. So during that process, these guys will also be working on the repayment plan. So the RP shall provide a report on the repayment plan within 30 days from the date of last receipt of claims. Sorry, it's not 30 days, it's 21 days from the date of last receipt of claims under section 102. So in this we had 7, we had 21, we had 30, and we are having 21 days again. Just kindly, sort of internalize this. So you may also use some little chart for you to understand yourself. So 21 days from the last claim date, he has to give the resolution plan. So another very good way of remembering is your critical dates are 0, 7, 28, 37 and 49. So if 0 is the date of the order, then these are the dates. 0, 7, 28, 37, 49, and you will be able to fit in the dates that I have spoken accordingly. Report of the resolution professional shall be submitted within 21 days of the last date of claim, and the report shall state that it's complying with the laws in force, it has a reasonable prospect of succeeding, and if there is a necessity of summoning the meeting of the committee of creditors. If the RP says, no, I don't need to have a meeting of the committee of creditors, there's only one creditor, why should I have a meeting? Then it shall also state the reason why he is not proposing a meeting of the committee of creditors. Now, if he does propose a meeting of the committee of creditors, then he should also say when is he going to have that meeting. It should specify the date and time and place at which the meeting will be held. In doing this, he has to consider the convenience of the creditor. Now, he had two options, either no meeting or yes meeting. If no meeting, why? If yes meeting, when, where, and at what time is he going to have the meeting? Now, apart from this, the Act also stipulates by which time the meeting should be held. See, one of the key features of this code is that it specifically says when you should do this within the 180-day timeline. So this Act also says that you need to hold the meeting within 14 to 28 days from the date of submission of the report. So please remember this particular section within the report, so it should be 14 to 28 days of the submission of this report. With this, we conclude 106, which is the report of the resolution professional. Only three things he needs to look. Is it complying with the law? Does it have a reasonable chance of getting approved? 3, meeting of the committee of creditors, whether it's needed, not needed, and its appropriate actions. Then, once you've decided, see, this meeting of committee of creditors is not one chumma meeting. It's not a meeting just like that. It's basically to ensure that they actually approve this repayment plan. That's the objective. And there it will actually say that 107, summoning of the meeting of creditors. 14 days notice is given here. No shorter period is given here. Okay? You must try and recollect parallelly what is the notice under the corporate resolution. So, and in corporate resolution, they provide for a shorter notice. Sharanya, just have a look at corporate resolution. Don't want to make a mistake and correct. The resolution professional shall send a notice of the meeting to only the list of creditors as per the Act. Okay? Whereas under the corporate, they shall send the notice of the meeting to members, partners and directors of the corporate debtor also. These are the little things that you need to appreciate in this section, even from an MCQ perspective. Notice of meeting only to creditors. Notice shall state, you must look at the regulations, Sharanya, for corporate. I think it's there in the regulation. The notice sent under the subsection 1 shall have a copy of the resolution plan, shall have a copy of the report on the resolution plan. 3, what is the statement of affairs of the debtor? And 4, forms for proxy voting. Okay? Now, if I were to contrast this with the corporate notice, there's a lot more. It will say the date, time, no, that's shorter notice, but the main notice is at 21 or 14. Correct. So, it's 7 days and 24 hours for a corporate resolution process. Then, so now you go to the next one. So, we were basically trying to distinguish between corporate resolution notice and this notice. Here, it is a 14-day notice with no provision for a short notice, whereas in corporate, it was 7 days with 24 hours short notice. Now, once the notice, again, let me contrast this with the notice under corporate. It's okay if you are taking a little longer, But notice under the corporate will specify the date, time, place, venue. It will state the list of matters. It will state the list of items to be voted. It will permit forms for proxy voting. It will also say that a voting shall not be taken unless all members are present. Those kind of additional aspects are included in the corporate process, which is not there here. So here it is only 4 things: resolution plan, the repayment plan, the report on the repayment plan, the statement of affairs, and the proxy voting. Conduct of meeting of creditors. The meeting of the creditors shall be conducted in accordance with provisions 109, 110, and 111. I am now in section 108. The meeting of the creditor may decide, in the meeting they can decide to approve, modify or reject. It's the creditor's prerogative, because they are the ones who are going to take a haircut. They are the ones who are going to work with the company to evolve a resolution. Then now is it possible to adjourn these meetings? Yes. Up to 7 days it can be adjourned. There, if you remember, in the corporate process, the usual adjournment is 1 day. And that too, that adjournment was only for a quorum purpose that it was specified. Okay, where it gets adjourned to the next date, where there is a lack of quorum of 33%. Now you might wonder, why in this act they have not given the quorum, the conduct, chairperson. All this will come in your regulations. Right? So with this, we finish the conduct of the meeting of creditors. So then, voting rights in the meeting of creditors. Creditor should be entitled to vote in proportion to his voting share assigned to him. Who will determine the voting share? By the RP as per the regulations of the board. RP can't just thumbs up his own numbers. Now, there are 3 voting restrictions on a creditor. 1. If he is not at all there in the list of creditors, which was submitted within 30 days from the last date of claims. 2. If he was an associate of the debtor, and you know what an associate is, no? Relative, spouse, spouse's relative, immediate family, partner, spouse of partner, relative of partner, company with 50% paid up share capital or control of the board of directors, trust, employer, employee, all this is relatives. You may quickly go to part 1 of this chapter and look again, just to reinforce who the relatives are. Associates are. Associates cannot vote. And third, a creditor cannot vote for an unliquidated amount. So what is an unliquidated amount? It's an unassessed amount. So I don't know. I know that there is a debt, but I don't know how much there is a debt. So how much voting share can I give him? I can't give him anything. So these are the 3 restrictions on voting that you shall remember. With this, we will stop here at 109. We have finished 109, 108 conduct, 107 summoning, and we finished 106 report on resolution plan, and 105 the repayment plan itself. We'll look forward to the next video on this.